All right, well, good afternoon, everyone. Thank you for attending the Michigan Indian Legal Services pro bono presentation today with the Detroit Mercy Law Veterans Law Clinic. My name's Norika Kita Betty. I'm one of the attorneys at Michigan Indian Legal Services and also work on the pro bono program along with Hank Fields. We're excited today for this program. And before I introduce our speakers, just a few housekeeping matters. Your lines should be muted to begin with. If you could leave them muted during the presentation so that we don't have any background noise or feedback. If you do have questions that come up, kind of general questions during the presentation, feel free to type them into the chat and I'll be monitoring that. Please keep the questions general. If you have a specific question about your own personal situation, the contact information for the clinic will be provided at the end, and you can always call individually to ask those questions. We also will have a time at the end of this presentation to talk about more general questions too. We are recording this presentation, so if you don't want your image recorded, please turn your video off. The recording will be available on the MILS website and also on our Facebook page once we have it ready to go. We are going to post a link for a survey in a few minutes here in the chat. And if you're able to fill that out after the presentation to give us a little bit of feedback, we'd greatly appreciate that. It'll also be posted on our Facebook page. And finally, we still have a few spots left in our upcoming Veterans Legal Clinic that MILS is holding the next few days. So if you are a veteran and have a legal issue, general legal issue that you're looking for advice on, you can contact Michigan Indian Legal Services. I'll also put that contact information in the chat, and we can try to connect you with a volunteer attorney. All right, so we're very lucky today to have Professor Margaret Costello and some of her students from the Detroit Mercy Law Veterans Law Clinic to give us this presentation to provide an introduction to veterans benefits. The Veterans Law Clinic helps lower income veterans, families, and survivors in obtaining benefits from the Veterans Administration. And since it was established in 2007, the clinic has helped hundreds of veterans and their families and recovered nearly $3 million in retroactive benefits, along with continuing monthly benefit payments. So today we have Professor Costello and two of her students. We have Mr. Michael Shannon and also Mr. Adrian Cormier with us. So with that, I'll turn it over to you, Professor Costello, and thanks so much for joining us today.
Professor Costello, you're muted.
Sorry about that. Thank you very much for having us today, Noriko and Hank. We are always pleased to provide information for veterans and those who work with veterans. So our presentation will be posted on the website for Michigan Legal Services. So if you or anyone you know want to go back and look at it later, you would certainly be encouraged to do that. We are going to be talking today very basically about veterans benefits. And so if you want or need more information, especially personal information, as Norika mentioned, please don't hesitate to contact us or seek help in the ways that we're going to be describing at the end of the presentation. And again, your questions are welcomed in the chat box. We'll try not to get distracted by taking questions during the presentation, but if you do have a question, put it in the chat box and we'll make sure that we get to all of the questions before we end the presentation. So I'm going to begin by sharing my screen so that I can have you see, along with me, the PowerPoint. And I will hopefully be able to do this without too much problem. Okay, can you all see that? My slide, somebody give me a thumbs up. Yep, okay, great. So this is a presentation, as I mentioned, on veterans' disability benefits. And it is going to be very, very basic, but we are going to do our best to provide some information that I think will explain a little bit about how these benefits work and what one has to do to be able to obtain them. So just a very quick introduction to our Veterans Law Clinic. We are located in Detroit. We're part of the University of Detroit Mercy Law School. And we were started in 2007. A former dean of the law school had the inspiration to start the clinic because of the press around that time regarding incidents such as the incident at Walter Reed Medical Center and others where veterans were not receiving the care or the benefits to which they were entitled. So we established that clinic. We were one of the first in the country to establish a veterans law clinic. I think we were second or third. Now there are over 50 around the country. And the purpose of our clinic is to educate and assist veterans and veterans attorneys on how to handle claims, how to deal with the VA and get the benefits to which they're entitled to. It's no easy process, believe me, and my students will attest to this. Clinic students actually represent the veterans under my supervision, and most of the work we do is work in the Veterans Law Clinic with the VA. We do some additional stuff, but most of it is regarding disability claims and benefits through the VA. We also recruit attorneys and legal assistants to provide representation and assistance to low-income veterans. So we also hopefully are expanding that scope of people who are available to provide veterans with legal help. And on that note, I'm going to turn it over to Mr. Shannon, who will take on the first bit of substance in this presentation.
Hey, hope you guys are all doing well today. My name is Mike Shannon. I'm a 3L at the University of Detroit Mercy School of Law. I'm also a veteran myself. I spent 4 years in the Navy as a hospital corpsman. So that's kind of hold a special place in my heart. So I'm gonna kickstart this off. So the Department of Veterans Affairs, at least for the benefit side, is really made up of two different administrations. You have the VHA, which is the Veterans Health Administration, and the VBA, which is the Veterans Benefits Administration. Again, these two aren't the same entities. The VHA is the largest healthcare system in the U.S. They service about 9 million vets, and they have about 150 flagship hospitals. Here in Michigan, Dingle is probably the most popular one, although there are some in Ann Arbor. I think there's smaller clinics in Wyoming, Michigan. It's also comprised of 800 outpatient clinics and 300 counseling centers. The VBA main office is in Detroit in the McEnany building. And the VBA is where you take your initial claim for benefit to, and they're the ones that will do the initial adjudication and make the determination whether or not the veteran qualifies for benefits or not. And I'll move on to the next slide.
I'm having trouble doing that. Excuse me. Sorry about that.
All right. So again, when the VBA is making their initial determination on whether or not a veteran is eligible for benefits, the first thing they're always going to ask is who is a veteran, or are they a veteran that an eligible veteran. So they're going to look to see if they served in the military, when they were discharged, if they were discharged other than dishonorable. They don't have to have been served in a war or anything. And then when it comes to National Guard and Reserve members, what they're going to look at is if they were actually pulled into active duty or not. And then in the course of being actually in active duty, did they injure themselves or not? And so they're just a little bit more of a hurdle to jump over as far as like your regular enlisted or officer in active duty. Professor?
As I mentioned, just want to add a couple of things here. So just so you sort of have the picture in your mind that when a veteran applies for benefits, the Veterans Benefits Administration, which hands out the money, is a different division of the Department of Veterans Affairs than the Veterans Health Organization or the Veterans Health Administration, which operates the Dingle VA, the Ann Arbor VA, the Battle Creek VA, the Grand Rapids VA, the satellite centers, as Mr. Shannon mentioned. The VBA has only one main office in the state of Michigan, and that is in Detroit. And that would be at the McNamara building, as was mentioned, on Michigan Avenue in Detroit. And that's where all of the claims processing and decision-making at the initial level for Michigan is initiated and takes place. And in order to qualify for any of these veterans benefits, one has to meet several criteria, the first of which is the veteran. One has to be a veteran, and you might think that's sort of, that sounds sort of ridiculous. Of course, if you served in the military, you're a veteran. But as Mike mentioned, one of the biggest hurdles that we see with veterans sometimes are people who were discharged from the military with an other than honorable discharge. So they may have served many years. They may have served 4 years, 8 years, 12 years. We have one veteran right now as a Purple Heart and nevertheless was discharged with an other than honorable discharge. And in those conditions, when somebody does not have a discharge that is either honorable, general, under honorable conditions, but it actually says other than honorable or dishonorable, that person is not considered to be a veteran, regardless of the fact that they may have served active duty time. And so that person is not going to be eligible for any benefits unless something is done to either change their discharge status or to make the VA consider them as if their discharge status was not other than honorable. And that is not an easy task. It's doable in many cases, but it's certainly not easy. So I just wanted to jump in with that so you sort of have a little picture of the landscape, that it's not a simple matter of just fill out the form and anybody who served could probably get some benefits. Michael's going to take you through the rest of the criteria for the service-connected benefits, and then later Mr. Cormier is going to talk a little bit about the other type of benefit, the pension benefit that we have. So Mike, I'm going to try my best to, again, something keeps going wrong when I try to do the slides. There we go.
Bring back one.
I don't know if I can do that. There we go.
All right. So VA compensation is commonly referred to as service-connected disability because that's what the service member is going to be getting compensated for. It's going to be compensation for a disability that had occurred in service, and this could be anything from an injury, a disease, or a condition that sustained or was aggravated in the course of the veteran's military service. Compensation is based off of a disability rating, and they base those ratings on a degree of how disabled the veteran is, and they almost kind of applied like workers' comp in a way where you get paid out more the more you can show that how the severity of the disability and that it affects your day-to-day life might prevent you from getting gainful employment, or some kind of aspect is where you're not going to be living in a way that you would have had you not been injured in the military. And so there's a few things with, in order to get service-connected disability that the veteran has to show. Veteran has to show that there is a current disability. So no compensation if the injury was healed. You know, you broke your leg and it healed up fine. You don't walk with a limp or anything like that. They're not going to pay out for that type of injury anymore because it hasn't sustained throughout your lifetime. Not to say that maybe a few years down the road, the broken leg, you know, might come into effect, but at the current time that you're asking for the disability, you have to show that that you have a medical diagnosis for that disability. They're not going to pay out for compensation for pre-existing or congenital disorders. They assume that it's because you had these conditions prior to coming into the military. However, I'll talk about that a little bit later when we get into presumption of soundness. Well, I'm on a presumption of soundness now, but again, the most important thing is that there's a medical diagnosis by a professional or a person with specialized training in that area that qualifies them to make a medical diagnosis. The injury had to have happened in service. So from the moment that you entered service to the moment that service ended, that's the time frame that they're going to look at to see whether your injury has occurred or not. So you can be diagnosed with cancer while you're in the military. They're going to say, okay, that was an in-service disease. You injured your leg jumping out of a plane, parachuting. Pretty easy to make that service connection there. It also includes things that aren't related to your job in the military. It also includes, you know, you're on leave, you get in a car accident, you're playing basketball in the rec center, you tear some ligaments in your ankle. So anything that happens to you in that time frame, you're going to be able to make a in-service connection to that. Generally, this will be established through the veterans' military records. The VA has a duty to help you obtain these things, obtain your official military personnel record, obtain any service treatment records. And this helps us generally by painting a fuller picture of your injury so that we can go back to the point in time of when the injury actually occurred. And so there has to also be a nexus between the current disability that you have and the service injury or disease. Typically, if you have medical evidence, the nexus is almost always going to be required to support the claim. And it's one of the most common reasons for denial is that the VA will say the injury that you have now or the disability that you have now, there's no connection between that and your time in the service. Again, the nexus is going to have to be provided by medical evidence. I don't really know. Yes. So yeah. So again, the VA must provide a medical examination for the nexus. Again, they have a duty to help you. So they'll provide what's called a CMP exam. And this is kind of one of the next steps after filing for a disability. where they're going to help you by kind of just examining you, but also it always helps to get another doctor's opinion. And that way, if there's conflicting opinions, it kind of works out for the, well, most of the time it should work out for the veteran. You know, they'll typically give the benefit of the doubt to the veteran. The magic words that we like to see when doctors are writing their medical opinion on the Nexus is as likely as not, or less likely as not, or more likely as not that this disability was connected to the patient or the veteran's time in service. I kind of skipped over something real quick. Aggravation and presumption of soundness. Presumption of soundness, when you join the military and you go through MEPS and get to do the duck walk and all the other fun stuff that they make you do, and you fill out that long questionnaire, if you don't put anything on that questionnaire, right, you say, hey, I'm coming in, I'm in a clean bill of health, then they take you as is. All right, they're going to presume that you are Michael Shannon, 100% fine, has never had a broken bone, a disease, or anything in his life, right? And so that kind of helps you out in a way, just because, you know, it points to the fact that, hey, I was perfectly fine before entering the military, and you said I was fine. There was no problem with me during my entry exam, and now I have these conditions. It gives me a little bit of a timeline that I can go back to and say, like, since I was in the military, I'm no longer sound. However, the caveat to that is, if on that entry exam you write down that, you know, I broke my elbow when I was a child, or I have this disease, all right, the presumption of soundness is no longer there for you, but you might have an argument for the presumption of aggravation. And that is when the veteran must show that the disability that they had put down was worsened by their military service, and that worsening was not a natural progression of that disease. So if I break my elbow and then I go into the military, you know, we're assuming my elbow is fine enough for active duty, and because I'm, you know, working on tanks, I'm having to torque a bunch of bolts onto a wheel well or something, you know, and my elbow starts to get worse and starts to hurt me even more and more and more. And over the years, it just deteriorates extremely fast. And it's not anything just because I had a broken elbow, but it was because of having to constantly exert it in my day-to-day duties as a service member. You know, then we have, then we can use the presumption of aggravation that, you know, yes, he did have this elbow injury, or she had this elbow injury prior to being in the military, or she had this disease prior to being in the military, but it was only worsened because of the military, because of what I did in the military. And the VA has the burden to prove that the condition would have worsened without military service, and that's when the VA will try and deny a claim. So I'll let
before we get into the next portion on Agent Orange, I just want to quickly review the takeaways. This was a lot of information that Mr. Shannon provided. I don't recall if he told you at the beginning, but he is a veteran himself, and now a law student. So I just want to give you real quick the takeaways, because there was a lot of information there. And so a service-connected disability claim is what most veterans are striving for, because that gives you money, and it gives you money that is tax-free. And there's no income requirement. It's completely based on whether you meet the criteria. And, you know, Bill Gates could get it just the same as a homeless person. There's no requirement about income or anything else. So basically you have to have and be able to demonstrate those elements, though, that Mike went through. One, being a veteran, and I talked a little bit about that a few minutes ago, about that means having a discharge that's not other than honorable and having served at least some time on active duty, as well as perhaps some other minor things. You also have to have a current disability, something that is currently affecting you at the present time when you file your claim. That has to be related to your military service. What does that mean? Well, that means it either has to begin during your military service, like cancer or ALS or some disease or something of that nature, or an injury that has to have occurred during your military service, or it can be something caused by your military service. So maybe it doesn't occur right then during the military, but later you start perhaps experiencing some emotional distress based on things that happened to you when you were in the military. So it can occur during the military service, be caused by your military service, or as Mike mentioned, be aggravated, be worsened by your military service. And in all of those cases, if you can show the link that what you're experiencing now is related to your military service, sometimes it's really obvious. It's in your medical records from the military and you still have the condition. But most of the time it's not so obvious. And that's where you need a doctor's opinion about it, what Mike referred to as the nexus. The VA will provide examinations, but often the VA's doctors may not be exactly what the veteran wants for an opinion. So he or she may have to get his own doctor with the credentials to be able to make an opinion about the link between their current condition and their service. And then finally, it's rated. It's not an all or nothing thing. So someone can have a service-connected disability and in some cases only be getting $100 and some a month or nothing even. And in other cases, they would be getting over $3,000 a month. So it's that the amount you get is based on how severe the disability is, how much it affects your the average person's ability to work. And so that's sort of the takeaways from service connection, from that portion of the really key things to kind of remember. If you obviously have questions, you can always go back to the video or we'll give you some additional information at the end. So now I'll turn it over to Mr. Cormier, my second student, who's going to talk a little bit about some other aspects of veterans benefits that might be of interest. Adrian.
Hey, everybody. So yeah, my name's Adrian. I'm also a third-year law student at University of Detroit Mercy. I'm also doing a concurrent law degree at the University of Windsor in Canada. That's actually where I'm living right now. So what I'm going to do first, I'd like to take you through what we call, or what the VA calls, presumptive service connection claims. And what these sorts of claims do, I'll take you through two examples. What these sorts of claims do is they remove the requirement for the veteran to demonstrate a nexus. So you don't have to go and prove that whatever your disability is connected to an event in service, because there's a presumption that's in your favor that says, hey, listen, this guy's disability is service connected just by virtue of the fact that you were there. So there are two of them that we'll go through today. One of them is Agent Orange exposure, which was during the Vietnam War. And the second one is during the service during the Persian Gulf War. So Agent Orange, and I'm sorry if I'm patronizing here by telling you what it is, but Agent Orange was a herbicide and a defoliant that was used in Vietnam by the U.S. Military. It was a blend of tactical herbicides that they sprayed during the Vietnam War for the purpose of removing leaves from trees and other dense tropical foliage that provided the enemy or the Viet Cong cover. So if you are a veteran who served in Vietnam between 1962 and 1975, and you're afflicted with one of the ailments that I'll show you on the next slide, then you have a presumptive connection of service. So you may just be entitled to a rating for one of these disabilities. So here's a list of disabilities. And I just want to sort of preempt this by saying that this is not an exhaustive list. This list there are new conditions that the VA is adding to this list, as time goes on. The VA goes through a study process in order to determine which diseases qualify for a presumptive service connection claim by virtue of exposure to Agent Orange. So what they do is they look at occurrences of the disease. Let's take non-Hodgkin's lymphoma. So they'll look at the general population of the United States, and they'll see, what the occurrence rate of non-Hodgkin's lymphoma is in the general population. And then what they'll do is they'll compare that to men who served in Vietnam during the period of time, between 1962 and 1975. And then if there is a statistically significant difference between the occurrence rate in the general population and the occurrence rate in the veterans, then what they do is they may add that disease to the list. So Persian Gulf War veterans, what this means basically is if you are a veteran who served during the Gulf War and you have any of these symptoms that are on the screen right now, so that is unexplained fatigue, skin problems, headaches that are chronic, muscle pain, gastrointestinal issues, or abnormal weight loss. And these symptoms can't be explained by a medical diagnosis. So that is that you go to the doctor every day, they acknowledge that you're having these issues, but they can't give you a diagnosis as to why. And then you may have a presumptive service connection claim for what they call Gulf War syndrome. So if you have any of these symptoms, again, without a diagnosis, you may not have to demonstrate a nexus if you served in the Gulf War.
So again, these claims, just to give you, again, one or two takeaways, this is a carve-out where the VA is actually making it easier to get certain claims than to have to go through the process that we talked about earlier of showing that you had a condition, that you currently have a condition, that something happened in service that either caused or created the condition or made it worse, or it began during service, and then having to make sure that you have the connection. So if your back injury now 40 years later, you're saying is connected to a fall you had 40 years earlier, you've got to have medical evidence to show that. These presumptive conditions take away that burden. So if you have any of the conditions that would be listed here, for example, under the Agent Orange list, and there are more than were on the screen, and you served in Vietnam, that's all you need. You're going to be presumed to have that condition. And then the only thing left to show is how bad it is now. So how much will you be paid based on the rating? Same thing with Gulf War syndrome. If you don't have a diagnosis and you have these nebulous kind of symptoms that can be attributed to your service in the Gulf War, you don't have to show anything more except the severity. So that's the significance of why we're pointing those particular areas out to you. There are other presumptions too, but they're not as common, such as if you were a prisoner of war, or if you suffered an injury or a condition based on nuclear stuff or radiation. So there's some other presumptions as well. And moving now into close to our final kind of segments here is a secondary service connection. Adrian.
Yeah, and you know what? I just wanted to say quickly. I mean, I know that I'm really motoring through here, folks. So I mean, if you need me to stop and say something again, re-clarify, or you want me to just slow the heck down, just throw it in the comments, and I'll do my best to sort of accommodate. So we're going to sort of shift gears now and move into secondary service connection. So we just went through presumptive, which, as Professor Costello just summarized, eliminates the need for you to demonstrate service connection because the VA presumes that there is. Secondary service connection is a little bit different, because what this does is if you have a service-connected disability, such as a broken foot. So you were in service, you broke your foot. You've received a service connection or a certification of service connection from the VA, and then your broken foot causes you to limp or walk abnormally on that one leg. And over time, that sort of deteriorates your back. Your lower back gets exhausted, fatigued because it's being used or overworked as a result of the limp caused by the bare foot, a broken foot. This condition, the lower back condition, once you receive a diagnosis, is what we consider to be a secondary service connection. So long as it's causally related to the first condition for which you received a service connection, I know I'm saying service connection a lot, so if I've lost somebody, just let me know, then you can receive service connection as well for a secondary issue. So now we're going to move on from secondary service connection and just talk a little bit really briefly about the relationship between you, the veteran, and the VA. So it's the system is meant to be, and it's designed to be non-adversarial in nature. It's not meant to sort of like a typical litigation process or like typical court setting where you see, a plaintiff against a defendant. It's not meant to put you and the VA at loggerheads with one another. Rather, the VA has what we call, and it's a statutory or it's a legal duty, to assist in the pursuit of your claim. So in broad strokes, what this means is that the VA has to provide records that are under their custody and control, which can assist you in the pursuit of your claim. And, pardon me, they have to let you know what you need to do in order to prove your claim. So for example, on a new claim form, if you were to submit a new claim form, there are a whole bunch of precursor pages before you get to the actual form. In these precursor pages, the VA lists the evidentiary requirements, or what you have to show in order to meet the threshold to obtain benefits for certain disabilities or certain claims that you're making. And that's one of the ways in which they fulfill that duty to assist.
So even though the veteran, by statute has a duty to assist, unfortunately, we often have to take the initiative, because the duty to assist often sounds much better on paper than it actually translates when the VA is attempting or purporting to be helping the veterans. And which is why advocates, attorneys, and others have to get involved, because it isn't, even though it's a non-adversarial system, the statute says it is, all these things are things the VA has to do. Often, frankly, they don't do a very good job with them. And if you don't put on your own claim and the evidence to support your claim, you're not likely to get it granted based only on the VA's assistance, unless it's a really simple, straightforward one. That's been our experience anyway. And now we'll turn to the last benefit that we're going to talk about today, which comes up relatively frequently, is VA pension. Adrian, you want to round that out?
Yeah, sure. So we're gonna switch gears again here real quick. So we're not dealing anymore with disability benefits. Now we're dealing with pension benefits. So it's a different type of benefits for which veterans may be eligible, which means they don't have to be connected. There's no nexus, and there's no application of the presumption to an event that happened in service. There are three sort of fundamental requirements in broad strokes that a veteran would have to meet in order to potentially qualify for a VA pension. The first is that they must be needy, which means there are certain thresholds set by the VA which the veteran must meet in order to qualify. Second, they must have served during a period of war. Now, a period of war is what's defined, is what is the prerogative of either the president or Congress to define. And it doesn't necessarily mean that you have to have been a combat veteran, but you have to have been in active service during wartime. And finally, you either have to be entirely disabled from work. So for you have a disability that disables you from being able to work entirely, or you've got to be above the age of 65. Now, there's also, sorry, were you going to say something, Professor?
Oh, go ahead.
Okay. So the maximum benefit, pension benefit, that a vet can receive under this regime is $13,752. So what this effectively does is it serves as a basement floor. It's essentially the VA saying, okay, if you're entitled to a pension, you're not going to make less than $13,752. Now, what do I mean by that? I mean that if you qualify, that doesn't mean that you're going to get $13,000. It means that the VA will supplement whatever your income is to the extent that it needs to in order to bring you up to that threshold. So if you work part-time or you receive other Social Security benefits for, let's say, $10,000 a year, the VA will supplement that $10,000 gross income with $3,752 per annum. And if, again, there's another little caveat there. If you've got medical expenses that you have throughout the year, let's say you've got, $5,000 in medical expenses and you make $10,000 outside of this pension. Well, the VA does a little bit of math and they say, okay, we'll also pay for the medical expenses. So what they do is they deduct the value of your medical expenses per year from your gross income. And then they'll supplement that income up to the level of $13,000.
So the important takeaways about the pension benefit, I think, are basically you've got to have a really low income for this to make any sense. And it's a dollar for dollar offset. So if you're getting some Social Security disability, that's going to be counted as income. If you're working at all, that's going to be counted as income. And for every dependent you have, a spouse or dependent child, that amount goes up. But you're also counting the spouse's income as well. And so that can be offset by medical expenses of you and or your spouse if you have or dependent children, if you have dependent children. But the bottom line is this is a benefit that's designed really for people of very limited resources, financial resources. And in addition to that criteria, you have to have served during a designated period of war, meaning that the United States, through its Congress or president, declare that time to be wartime. So there's a big gap between the end of the Vietnam era and the beginning of the Gulf War era, basically almost all of the 70s into the early 80s, where veterans simply won't qualify for this benefit. End of story. And then, of course, you have to also be permanently and totally disabled from working or over the age of 65. And so not many people qualify for this benefit, or at least all of it. Some people who don't get very much in Social Security may supplement them, as Mr. Cormier mentioned. So it is another benefit not at all related to your military service in the sense that the disability doesn't have to be related to your military service. You still have to be a veteran, a qualifying veteran, but has nothing to do with whether your current disability that causes you not to be able to work is related to your service. And so I want to end just by a few things that I think it's important to note. One is that if you or someone you know, or you're talking to someone about applying for veterans benefits, I would suggest that they obtain assistance. It is possible to do it on your own. Many veterans do. But if you can get assistance, I would suggest you do so. That's either through a clinic like ours, the Veterans Law Clinic, and I've put our call number up there. Through your county veteran service organizations, if you have one in your county. Not all Michigan counties do, but many do. Or a veteran service organization like the American Legion, the Vietnam Vets of America, the Veterans of Foreign Wars. They have service officers who are not attorneys, but they're trained and able to help veterans apply for benefits. There's no time limit to apply for benefits. So if you served in World War II and you're still getting around and you never applied for benefits and you decide now is the time, you can apply if you can meet the criteria. The other interesting thing about veterans benefits is you can reopen a denied claim at any time as long as you have new and material evidence. So if your claim has been denied, even if it's been denied 5, 6, 7, 9 times, you can still reopen it as long as you have new and material evidence. So what do you do? How do you apply for benefits? If you've never applied for benefits, and you think you might be eligible for either pension or a service-connected disability benefit that we mentioned, there are some other benefits too, but they get a little more complicated. We're not going to try to deal with those today. You would submit the intent to file form. All that does is set your time running, your clock running. because the payment of your benefits will occur from the date you file your claim. So if you're not ready to file your claim yet, but you say, gee, I think I have a claim for a back injury I got back in Vietnam, but I've never filed a claim for it, file that intent to file form. You have, all it does, it doesn't even ask you what your claim is. It just says, I intend to file a claim. And you have a year then to file that claim from the date they receive that form. And so therefore, if you're successful, your benefits will be paid back to the date you file that form. If you're not successful, or if you decide you don't want to file a claim after all, it'll just disappear. It won't harm you in any way. And if you don't know exactly how the claim should be articulated, it's a good idea to do the intent to file form, because then you have the time to kind of sort it out. Always obtain a copy of your discharge document, your DD-214. They're always going to ask you for that when you file a claim. If you already have one on file at the VA, that's fine. But if you don't, you're going to need a copy of that. And then when the time comes to file a new claim, you will be filing the Form 21-526, which is an application for compensation or pension. Same form, fairly long, not terribly, but long enough that it's kind of a hassle to complete, but that's what you've got to do to file a new form. Now, after you file the claim, it doesn't end. As I said, we don't trust, and you shouldn't trust, the VA to do everything it's supposed to do on paper. So you need to get your medical records to support your claim. You need to request your military personnel records. If you're working with a service officer or a veterans clinic, or an attorney, they will do that for you, but you need to do that. Excuse me. You also need to gather any statements from others that would support your claim, that support that you really did have a fall, or that your condition affects you in a certain way, or that your psychological state has changed after service. So any statements you can get. Medical opinion, as I mentioned, the VA will do that for you, but better for you to also try to get your own medical opinion from your treating doctor or from another doctor if you don't have a treating doctor. VA docs who are treating you, not the best, because they think that's kind of a conflict of interest. Some will assist, but others don't see that that's their role. And then if you lose, which is often the case, more than probably 2/3 of all initial claims are denied, then you really should seek assistance. Don't try to go any farther on your own. You have a year to file an appeal. Most of our claims are decided successfully after appeals, not with the original claim. And since 2019, there have been a number of changes in how you file an appeal, and we're not going to go into great detail, but you do have some choices. You can either submit new evidence and appeal it that way with the supplemental claim. You can not submit new evidence and basically argue it was the wrong decision with a higher level review, or you can directly appeal to the next level, the Board of Veterans Appeals. And there you can make the decision whether or not you're going to submit new evidence at that level as well. So there's three at least, options for appealing. The important thing to know is that you've got a year from the date of your decision if you want to appeal and keep your effective date. Keep the date so that if you are successful, your benefits will be paid from the date you originally filed the claim. And that can be important because if you stay in this appeal loop and it takes a long time, your back benefits can be fairly significant. We just had a veteran last week who got her claim granted by the board in a case that we've been working with her on since 2013. And so she's going to be getting probably in the area of $250,000 in retroactive benefit, plus her new monthly benefit. That's really the end of the story for us today because we don't have a lot of time and we wanted to give you really just a brief overview of the crux of the matter, what the benefits are that you can strive to get. And as a veteran, or if you're helping veterans or no veterans, and also what some of the key principles or criteria you have to be aware of so that You're not in that camp of veterans who call us and say, well, I must be eligible for something. I don't know why, but I got to be eligible for something because I'm a veteran. And that's not very helpful, because the answer is not really, not unless we can demonstrate one of these areas where you would be eligible for benefits. So I don't know, Norika, do we have anything in the chat room for questions? We have some time left.
We do, yeah, we have a few questions. The first one is, how may I receive a VA-backed home loan as the surviving spouse of a veteran? Is that something you can answer?
Yes, I can speak to that. So it really depends on, as a surviving spouse, it's a little bit more difficult. As a veteran, it's him or herself, it's easy. So the simple answer is you can do one of two things. You can either go over to the VA, which is the absolute easiest thing to do. But of course, if you don't live in the Detroit area, and now with COVID, everything being closed, that's probably not the best option. So second best option is go to the VA's website, va.gov. You might want to put that in the chat room, somebody, va.gov. And search for home loan, and it will give you the application, and it will tell you what to do. All spouses of veterans, deceased veterans, may not qualify for that benefit. There are some restrictions, so make sure you look at the qualifications, see if you're going to qualify, and if you are, you fill out the application. They don't give you the money, they guarantee the loan. So it's easier for you to get a loan through a bank, because if the VA is going to be guaranteeing $60,000 or $80,000, obviously a bank's going to be more amenable to loaning you money. Other questions?
Okay.
Question there related to dishonorable discharge.
Oh, you're going to take that one from me.
Oh,
No, it's just to show that I paid attention in class yesterday. So you take it away, Mr. Cormier.
It's all you, my friend. Go for it.
So some examples of less than honorable discharge would be a general discharge. Under a discharge like that, typically the veteran wouldn't be eligible for VA benefits.
Not true. Whoa.
Under general discharge,
you
honorable discharge, the veteran's eligible for all VA benefits. A general discharge, you'd be able for benefits as far as service-connected disabilities, but you will not be able to be eligible for VA educational benefits under a general discharge.
That's the only thing that you wouldn't be eligible for. You'd be eligible Correct. For all the other health care and other benefits other than the VA.
Correct.
Yeah.
Another example would be OTH, just says other than honorable discharge, bad conduct discharge, or dishonorable discharge. And those three, you're not going to be eligible for any VA benefits, education, disability, or otherwise. I think there was a question about also, can you get this changed? And the answer is, well, I'm going to give you the law school answer. Depends on your case. But you can get it changed. And there are quite a few steps involved in it. But typically, you want to try and get changed within the first 3 years of being discharged from the military. And you have to go to that specific branch's review board, discharge review board, in order to adjudicate and get that changed to honorable discharge or general discharge, other than dishonorable discharge, in order to receive benefits. And correct me if I'm wrong, Professor, you have, it's at least 15 years for the DRB, and at the same time you can also file, you'll file a DD form 293 with the DRB, and then at the same time, you can also go through the Board of Correction of Military Records.
Not at the same time, no.
No?
So,
I'm not sure you do them like coincidentally, but the Board of Correction of Military Records, they won't necessarily correct the discharge, but they'll allow you to have benefits.
not true. Okay.
Okay.
Everything was right until the very last sentence, Mike. Good job, though. This is a tough area. My students generally don't work in this area too much. But everything Mike said was true up until the very last statement. So there's two options for changing discharges. One is the actual Department of Defense options, which are your board for which Mike mentioned, the Discharge Review Board. That's your first choice, but you got to do it within the first 15 years. If you're beyond 15 years, or if you've already failed at the board, a Discharge Review Board, then there's the Board for Correction of Military Records. That's your second choice, but it can't do them both together. You got to exhaust one first and then move on, or you can just ignore the Discharge Review Board and go straight to the Board for Corrections, but that would be a little stupid because you wouldn't get as many bites of the apple. Concurrently, what Mike, I think, meant to say at the end is you could also seek through the VA for them to recharacterize your discharge. That doesn't mean it gets changed. You still have your bad discharge. But
That's what I was thinking of.
Yeah, right. That's what I thought. But they will treat it as if it is not a bad discharge for either treatment purposes, so you can be treated at the VA, or for money purposes in some instances. So you can, that's again a tough road to hoe, but it can be done in some cases if you have the evidence. And so this is one area where I would never, never, never say do it alone. You need help to do this. So seek out a clinic, an attorney, or an organization that specializes or that at least gets involved in doing discharge upgrades or recharacterizations, because it's way too tough to try to do on your own. And just simply filling out the form, which many veterans try to do, and saying, oh, I deserve to have my discharge upgraded, is not going to cut it. In some cases, you're with the discharge review boards, you're allowed a hearing, and that can be done telephonically. So you want to do that if you have the opportunity. You always want an opportunity for a hearing, because then you can humanly present your case. So yeah, it's tough. But if you have questions, again, our number's up there. We don't do a lot of these in the clinic. We are very selective about the discharge upgrades we do, because they're very tough to get.
All right, and it looks like there was one more question about how to find out if you're eligible for VA education benefits as a dependent. And it does look like Mr. Cormier posted a link to a website there, but I don't know if there's anything else generally anyone wanted to say.
Yeah. Generally, if you're a dependent of a veteran, you're not eligible for educational benefits. You're only eligible if your parent, or I guess it would in almost all cases be a parent if you're a dependent, or your spouse. You could be a dependent spouse. If your spouse or parent is completely and totally, permanently and totally disabled, that's the only way you're going to be eligible for educational benefits, except, as I think Mr. Shannon or Mr. Norris, one of my other students, pointed out to me yesterday, if you are a post-11 veteran and you meet the criteria and you assign your benefits to another family member. That would be an unusual circumstance, but it does happen. So Mike is a veteran, say, and he doesn't want to use it.
Like if I didn't want to use my GI Bill, or actually I have a friend in the military, he finished his undergrad degree using tuition assistance while he was in service. So he had his full GI Bill benefits after he left services, and now he's assigned them to his son so that he can go to school with his GI Bill. But I think that only transfers when the veteran is alive, so it wouldn't transfer after death. And so it'd be something that the veteran that holds the benefit would want to do, like while they're while they're alive still. So
if they're eligible, because under
and
the
again, it only applies to the 9/11 GI Bill. It doesn't apply to the Montgomery GI Bill or anything before that.
and the post 9/11, you have to pay into it. You know, not everybody that enters the military gets educational benefits like they did back in the day. So you may not even opt for those benefits, but it is something, again, to consult somebody about if you have any questions. If your parent or spouse dies of a service-connected disability, that also will get you eligibility for education benefits. Any other?
Right. Those were all the questions in the chat, at least. And I did just post our survey, a link to our survey there. So if you're watching today, if you could take a few minutes and complete that for us, we'd appreciate it.
I'd like to thank everybody that joined us today and those that will be watching it. Those that, if you're watching this in the future after the 17th of November, we want to welcome you and thank you also for watching and gathering this information. And Mr. Cormier or Mr. Shannon, any parting words before we end, if we have no more questions or comments?
No, just thanks a lot for the opportunity, and we really appreciate everybody coming out to hear us drone on.
They don't actually have to come out anymore, right? You just have to go over to your computer.
For logging on.
These days, we hope we can see you in person sometime soon. We're working remotely right now from our clinic, but you're welcome to call, and we're doing our best, and actually it's going relatively smoothly, doing everything remotely. But hopefully by spring or summer, we'll be able to be back in person and welcome you into the clinic if you want to come by and visit us in person. Thanks.
Yes, well, and thank you all so much to Professor Costello and Mr. Shannon and Mr. Cormier. It was very informative, and we really appreciate all the time you spent putting this together. So thank you so much.
We're happy to come out to any organizations that want a presentation. So if you belong to a veterans organization or you have, you know, someone you know who does, and they're saying, hey, we'd like to learn a bit about what we might be eligible for, we can do that either by Zoom these days or hopefully in person sometime soon. Thanks.